Welcome to our final panel of the UNCLOS at 40 hybrid conference. Thank you very much for sticking with us all the way through. Without further ado, I would like to introduce the moderator of this panel, Mr. Lionel Yee, who's the Deputy Attorney General of Singapore, the Attorney General's Chambers of Singapore. Prior to his current appointment, Mr. Lionel Yee held appointments as the Solicitor General, a Judicial Commissioner of the Supreme Court, the Director General of the International Affairs Division in the AGC, which provides advice on public international law to all agencies of the Singapore government. Mr. Yee, without further ado, please go ahead.
Thanks very much. Well, good afternoon, and for those of us who are calling in via Zoom, good morning or good evening, as the case may be. I'm going to be fairly efficient insofar as running this session is concerned, because I think we do have a deadline to vacate this ballroom. So what I'm going to do is we have with us Judge Peck from UNCLOS, Nilofer on my left, Professor Koh on my right, and also online Ambassador Marie Jacobson. And what I'm going to do is very briefly introduce them before I ask them to make their individual presentations. The full profiles can be found on the conference page of the CIL website. So I start first with Judge Jin Hyung Peck. He's participating online in this session. He's a judge of the International Tribunal for the Law of the Sea and has been since 2009 and was the president of UNCLOS from 2017 to 2020. He was and he is a professor of international law at the Graduate School of International Studies, Seoul National University, and for the Center for International Law, he's a member of the Center's International Advisory Panel. Judge Peck will speak on the continuing relevance of UNCLOS, and I think as a member of the tribunal, I think we have certainly seen the tribunal being having a much, well, in a way, not just a continuing, but in fact, I think a growing impact looking at its caseload. So Judge Peck, it's a pleasure to have you, and you have the floor. Judge Peck, you may have to unmute yourself. Yeah.
Okay. Thank you, Mr. Yee, for your kind introduction. First, I want to thank the organizer for kind invitation to this important conference. 4 decades ago, in 1982, the United Nations Convention on the Law of the Sea was adopted after almost a decade of strenuous negotiation to establish a new legal order for the world's oceans. As the preamble of the convention declares, what the state parties aimed at achieving in their endeavor was to establish through the convention a legal order for the seas and oceans. The convention was thus intended to constitute the foundation of the comprehensive legal order for the world's oceans. Now, 40 years later, what is the state of such legal order established by the convention? How effective this legal regime has been in promoting the peaceful use of the oceans? What challenge is it faced with? These questions, I'm sure, have been addressed in the previous sessions. In this wrap-up session, without repeating what has been already said, I will briefly overview the current state of the legal order established by the convention. Obviously, it is one thing to adopt the convention. It is something else to ensure its implementation and compliance.
Can you hear well?
It would be naive to suppose that the adoption of the convention would automatically lead to the effective functioning of the legal order it established. In my view, an effective legal order requires at least three elements. First, there should be a well-developed body of laws. Second, there should be a well-developed body of institutions to implement, apply, and enforce such laws. And third, there should be a positive attitude of the members of the community toward the laws, such as commitment to and willingness to comply with them. They are, of course, closely interrelated. However, only when all three requirements are satisfied and synchronized with each other, we can expect the legal order to function effectively. For the first requirement of laws, I can point out that the law of sea is one of the most well-codified branches of international law. Of course, the convention is the centerpiece in this regard. It covers almost every aspect of the use and protection of the ocean. In addition, the convention incorporates various other rules, standards, and procedures developed elsewhere into the ambit of the convention. The fact that the process of making convention was equitable and democratic, with the active participation and substantial contribution of developing states, has further strengthened the value and acceptability of the convention as legal norms. On the other hand, many provisions of the convention are often criticized for being vague and overly general. The lack of precision was to some extent inevitable, as the convention was a product of package deal based on a delicate balance between conflicting interests. However, at least so far, this has not been a serious source of instability. For the second requirement of institution, generally speaking, this is an area where international legal system is relatively weak. However, the convention may be an exception in this regard, with the three major institutions created to facilitate and ensure the implementation of the provision of the convention, as well as various other institutional networks. While each of these institutions may have its own shortcoming, or there must be something to be improved, I believe that overall they have served their purposes quite well without major malfunction. In addition, the comprehensive system of dispute settlement with a compulsory procedure has also played a key role in clarifying and elaborating rules and thus stabilizing the convention regime. The third requirement is the positive attitude of members of the community, that is to say, the attitude of states toward the convention. Ultimately, the effectiveness of any legal system depends on the attitude of states, namely whether states are committed to and willing to comply with the rules in good faith. Despite all the progress made in law and institution, if states do not take law seriously, we can hardly expect the legal system to function effectively. Obviously, it is not an easy task to measure the attitude of states. One indicator may be states' willingness to submit its disputes to international court or tribunals. In this regard, I can note that maritime disputes have frequently been submitted to international courts or tribunals. In fact, maritime disputes have been the most popular subject of international adjudication, only next to trade disputes. However, what may be more important is whether a state recognizes and respects law in its everyday interaction with other states. I think as far as ocean affairs are concerned, International legal consideration now plays an important part in the decision-making of many states in their relation with other states. States may have different views as to the interpretation or application of the provisions of the Convention, but it is worth noting that many states refer to and rely on the provisions of the Convention to explain or justify their actions one way or another. At the same time, one cannot fail to notice some troubling trends in this regard, such as various practice clearly deviating from the provisions of the Convention and the refusal to appear before International Court or Tribunal, just to name a few. Now, 40 years after its adoption, it is my assessment that the legal order created by the Convention has worked fairly well in promoting the rule of law at sea. The Convention has almost achieved universality with 168 states parties so far. Since its adoption, two additional implementing agreements have been adopted and entered into force, and third is currently under negotiation. The UNCLOS regime is stable, yet flexible enough to accommodate any necessary changes. As the Convention ages, the inevitable question that will arise is, I believe many of us should reflect on, whether the Convention, which is essentially a product of political, economic, scientific, and technological conditions of the 1970s, can remain relevant to today's changed circumstances. This is the kind of question that can arise for any international agreement, but it may be more pressing for the Convention, not least in light of its close relationship with science and technology. Of course, technological innovations did not stop with adoption of the Convention. On the contrary, technological developments have further accelerated since the adoption of the Convention and will continue to do so in the future. In fact, the drafters of the Convention were well aware of challenges that lay ahead of the Convention, which they negotiated. They expected that the circumstances and conditions in which Convention operates would inevitably change, and this could seriously affect the relevance and viability of the Convention. They thus found it necessary to draft the Convention in such a way that it could adapt to subsequent changes and developments. Looking back the past 4 decades, I believe that UNCLOS has adapted successfully. It has been relevant to a broad range of issues that simply were not conceived of or anticipated at the time of its adoption, and it will continue to evolve in such a way to be able to meet new challenges such as climate change and protection of marine biodiversity. This does not mean that there will be no limit to the evolution of the Convention. As international treaty based on the package deal, the Convention may not evolve beyond the fundamental ideas and principles underlying such deal. I do not know whether or when a tipping point will come. I do believe, though, that we are not yet close to such point. In closing, in my part of the world, in Asia, we pay due respect to the teachings of Confucius. Confucius famously said that when he reached age 40, he was no longer confused or tempted. I don't know whether the Convention has reached the stage of no confusion or temptation, but I'm certain that UNCLOS at 40 still constitutes the solid foundation of the legal order for the world's ocean. Thank you.
Well, thank you very much, Judge Pig. I think there may have been a bit of a problem with the sound system, so I'm just going to briefly summarize what at least I was able to hear. I believe, Judge, you analyzed the UNCLOS regime from the perspective of its laws, its institutions, as well as the attitude of the state's parties to it, which is important, I think, for its effectiveness. And your assessment was that the legal order was working fairly well, with a large number of states being party to it, and also the implementing agreements that have come about from it. And you then asked whether it could remain relevant, and I think you observed that it had a built-in flexibility to adapt to the developments over the past decades, especially technological developments. So your assessment is that the regime has been able to stand up to the challenges of the past 40 years and should be able to continue to do so. At least it was not, in your assessment, close to a tipping point where it was unable to respond to the changes. So that's, I think, I hope I accurately summarized your presentation. I'm going to turn now to our second panelist, Dr. Nilofer Oral. She's the director of the Center for International Law, a member of the International Law Commission, and has been since 2016. And she's also the co-chair of its study group on sea level rise. Nilofer was previously advisor to the Foreign Ministry of Turkey on matters relating to the law of the sea and climate change, and she's the chair of the Academy of Environmental Law and co-chair of the specialist group on oceans, coasts, and coral reefs of the International Union for the Conservation of Nature. She's actively involved in, I think, some of the most pressing issues of the day, climate change, sea level rise. I think you've heard this in the course of the proceedings today. And I know that she is actively following them because she has been following the BBNJ Intergovernmental Conference, even though it's really odd hours here in Singapore. So I think, Nilofer, you're going to address us on, in a sense, the achievements and the gaps of the regime. And I suppose it is boiled down to a question is, if UNCLOS remains a constitution of the oceans, what is the state of the union? So over to you, Nilofer.
Thank you. Thank you so much, Lionel. And let me make a sound check. Can you hear me okay? Yes? Okay, very good. Thank you. Well, these have been really 2 days, a day and a half, in deep immersion in our dear instrument, UNCLOS, and how lucky we are, truly fortunate that we are sharing this commemoration with those who actually were part of making the convention, the founders, outstanding world-renowned expert scholars. And we've gone through so many issues in a very brief time. And yet I will start off by saying that I am of the firm belief, and having participated in a few negotiations myself and looking at other instruments, I don't think we could have an UNCLOS today if we were to sit down and try and to negotiate it. I don't think we could have the same instrument that would achieve the breadth, the depth, the ambition, and innovation of the convention. Yet when Ambassador Ardo Pardo made his historic speech to the General Assembly that launched the Seabed Committee in 9 years of very intense negotiation, it was in a very different world than today. And while we see today as a divided world, it was, UNCLOS was negotiated in a just freshly post-colonial and at the height of the Cold War, and yet it was successful. So I think we really need to go back and study, how this was achieved, how compromise was made without, in my opinion, diluting the ambition of the convention. I actually find it to be very clear in many aspects, even though there was compromise. And as I said in my opening talk, UNCLOS went beyond just codifying what existed, but created new norms, new rules, new regimes, new maritime zones. We heard from Daphne today about new navigational regime, the transit passage, the institutions that were created. The common heritage of mankind regime, absolutely revolutionary under Part 11. While it was not the first declaration, it is still, 40 years later, the only regime, detailed regime. So I don't think we can ever really should underestimate that. Of course, Michael Lard spoke to us about the ISA, and of course, Judge Rudico Wolfram, in his own way, really brought out the common heritage principle within the notion of a broader community interest and really looking at the convention as that should be its objective, that broader community interest. Part 11 on protection of the marine environment, and we were talking with Judge Caroma, and he reminded me, of course, dear Judge Yankoff, who I knew very well, and who was the chair of the committee that negotiated and drafted Part 12. Remember, this was in the 1970s, just the beginning, the Stockholm Convention. Environmental issues were really quite new. And yet the convention made some of the clearest obligations for protection and preservation of the marine environment. It really is, in my opinion, Article 192 stands unrivaled. Article 194, I don't think we can possibly underestimate the importance and power of these provisions. And I appreciated very much our speakers today, Professor Kujomo, who explained really wonderfully the systematic integration of post-UNCLOS principles into the current application, implementation of it through ITLOS and arbitral awards. We also heard from Nengui and Yuna really telling us the importance of that provision, that part, but again, there are challenges that remain. Now, as comprehensive as the convention sought to be, and in many ways was, gaps have emerged. And I'm just going to focus on one in particular, and that is something that has been talked about absolutely superbly by my dear friend, Clive Schofield, and of course, Tim Stevens, and that's climate change. Climate change, sea level rise, climate change, ocean acidification, climate change, ocean warming, chemistry change. And climate change emerged only as a concern of the international community, and I appreciate Clive's comments that it had been studied earlier, of course, sea level rise, but really in the late 1980s, and amazingly, we have Malta again to thank, who actually introduced it into the General Assembly in 1988. And now it's become the dominant issue, frankly. Climate change and its impacts on the ocean, unfortunately, and this was really brought out so well in the presentations we had, its impacts on baselines, maritime entitlements, status of islands, rocks, low tide elevations, ocean acidification. The Law of the Sea Convention understandably could not address these issues because they were not really raised at that time, and they would have been. I'm sure the convention would have addressed them at the time, and I think Clive made that point very clear as well. So Professor Stevens asked, will UNCLOS be a passive receiver or active responder to climate change? And I agree with him that the provisions of the Law of the Sea Convention have direct bearing on climate change, but have been underutilized so far. So the question is, how do we respond to this? And I think we've had some excellent discussions in these 1.5 days on the different modalities that were really wonderfully summarized by Judge Hyder. But I want to draw attention to our dear colleague who's here with us, Natalie Klein, who's done a lot of work on informal lawmaking. And there's a few of us here in the room who are very fortunate to contribute it to her groundbreaking book, on unconventional lawmaking in the law of the sea. So we have to look to different modalities, and if there's one case in point, it is climate change and the ocean, and specifically sea level rise. And while soft law or informal law making may not necessarily create binding, but they do influence state behavior, and this is what's very important. And this is what we need to do with UNCLOS, filling those gaps, is to really galvanize states to take the necessary actions and measures. So having said this, one issue as well is advisory opinions. UNCLOS has already given 2 excellent advisory opinions. Of course, one was the seabed chambers, but the other was the full tribunal en banc. Now, the possibility of an advisory opinion to address these gaps in the convention, specifically in relation to climate change. So I think that that certainly is one, and I'm somewhat involved in one of the commissions now that was established. So we have to look at different tools. And just last, because I don't want to speak too long, Tara raised an issue that I have thought about quite a bit, and that is the decision-making process, the governance, the gap in the Law of the Sea Convention. Yes, there is the SPLOS, the meeting of the parties of the states, but it really hasn't lived up to its potential. And if there's one area where we really could benefit from a more robust SPLOS that addresses substantive issues, not administrative, that is climate change and ocean issues. Because it has worked very effectively in other regimes. Anyway, I'm going to stop here and just say that in conclusion, I think we've heard a lot about the strengths. There are certainly gaps, but I also can see that it is a very dynamic convention. Perhaps at one point there was a point where some of the founders were concerned that they'd resolved all the issues and maybe the convention wouldn't be relevant. It's highly relevant now. And I think it falls upon all of us to really actively promote the implementation of the convention through all means possible. So thank you very much.
Well, thank you. Well, thanks very much, Nilofer, and thank you for sort of bringing together some of the strands that have been emerging in the course of the past 1.5 days, for identifying some of the gaps and for observing that the convention has a certain dynamism that sort of provides some of the tools that we could possibly use to address some of the gaps. I'm going to turn next to our third panelist, and she's Ambassador Marie Jacobson. She's going to participate online in this session. She's the Principal Legal Advisor on International Law at the Ministry of Foreign Affairs of Sweden. She was a member of the International Law Commission from 2007 to 2016 and was its Special Rapporteur for the topic protection of the environment in relation to armed conflicts. She's also, I think, Associate Professor of International Law at Lund University, and has done a lot of work on the Baltic Sea and polar areas, as well as on peace and security and environmental issues. And I think we've heard a lot in the course of this conference on new challenges that face the law of the sea regime, in particular from technological advances. So Marie, you will be, I think, addressing us on the issue of where the UNCLOS regime is heading and whether it can meet the challenges that have been identified. So over to you, Marie.
Thank you so much, Lionel. Do I hear an echo?
We can hear you fine.
Okay, so as long as you hear me fine, I can. I have to. I have to live with the fact that there is an echo for me, but that's perfectly fine. So again, thank you very much, Lionel, and dear friends of the Law of the Sea Convention. I would like actually to start by thanking Professor Tommy Coe and Dr. Nilofer Oral for inviting me. And I so sincerely regret that I cannot attend this conference by being present in Singapore. I was so looking forward to coming and meet you all and to have those very important chats and stimulating discussions. But regrettably, I had to change my plans due to the plans due to the tragic situation we see here in Europe, which affects my country very well because we are very close to Ukraine, and Ukraine is the victim now of a very aggressive war, as you know. But let me continue by congratulating you all to a very interesting and inspiring conference. And the topics chosen are very pertinent. All of them are issues that were emerging when the convention was concluded or have surfaced during the decades that have passed since then. The most important successes throughout the 40 years is that the Constitution of the Ocean has managed to encompass agreed text and ambitions while allowing the future regulations to be developed within its framework. Many, if not all, of the speakers have answered the question if the Convention has managed to address the number of new unforeseeable developments and concern affirmatively. So new and unforeseeable developments have not threatened the Convention and have not required a new comprehensive convention. The main reason for this are some particular qualities of the Convention, and I would like to put forward a few of them as examples of the resilience of the Convention. Previous speakers have touched upon most of them, I think. In my mind, they relate to four: the connection between the Convention and the UN Charter. The second is the compulsory dispute settlement system. The third is the encouragement and obligation in the Convention to cooperate and to develop further agreements. And the fourth is the protection of the environment. I'll start with the first, with a few comments on the connection between the Convention and the UN Charter. The preamble of the Convention makes a very clear connection to the UN Charter and also reminds that matters not regulated by the Convention continue to be governed by the rules and principles of general international law. And Article 301 sets out on the peaceful purposes of the sea, clearly sets out the connection with the Charter of the United Nations, and it places the Constitution of the Oceans within the framework of the Constitution of the international community, that is the UN Charter, and its rules-based international order. Article 311 that addresses the relation between other conventions and international agreements is also of direct relevance in this context, because the Convention has been supportive of addressing the broad dimension and implication of modern security threats: maritime security, terrorism, piracy, drug smuggling, and human trafficking. These are examples of matters that the international community, regions, and individual states have had to address through the lenses of the Convention when they further develop measures to combat such threats. International and regional organizations have to rely on the Convention while at the same time expanding their own instruments. The UN Security Council, the International Maritime Organization, regional cooperation, proliferation security arrangement, cooperation to combat drug trafficking, or for that matter, IUU. Most of the measures are carefully drafted in line with the Convention. It is, for example, very interesting to note how the Security Council has interpreted and maintained the balance of interest built into the Convention when it has drafted its resolutions on piracy and adopted other measures under the provisions of the Charter. The second feature in the Convention of utmost importance is, of course, the compulsory dispute settlement system. It is an innovative element has been successful if we look at the number of cases that have been subject to these procedures. In this category, I include advisory opinion and preliminary measures. And I'm also particularly happy to note that the instrument of conciliation, so often forgotten, has been used and was discussed yesterday by Judge Kuroma. But, as Professor Natalie Klein pointed out, it is useful to further examine whether the judgment and orders have been implemented. Or is the process of solving the dispute good enough, even if it's not in itself properly implemented? We can note the few occasions when states have refused to attend proceedings or to implement a decision or order, or even worse, not recognize the procedure as legitimate. That is worrying, since it means that those states place themselves outside the rules-based international order that they themselves have created and, through their own sovereign decision, accepted, instead of going to the court and arguing their case before a court and in a court proceeding. But dispute settlements relating to law of the sea matters do not only take place under the dispute settlement procedures of UNCLOS. On the contrary, today we find the provisions and principles of the Convention reflected in other legal proceedings. It is used and referred to in the European Court of Human Rights, in the Court of Justice of the European Union, in the WTO dispute settlement procedures, and not to forget domestic court and private arbitration. To go back to the dispute settlement procedures under the Convention, I wonder if not the most important article in this context is 293 on applicable law, which provides a court or tribunal having jurisdiction under this section, that it shall apply this convention and other rules of international law not incompatible with the convention. The provision gives a very clear indication that jurisdiction of courts and the tribunals established under the convention are not confined to the very specific provisions under the convention, but they shall apply also other rules of international law. In fact, the International Tribunal for the Law of the Sea made this clear in its very first case, the Saiga, in 1999, when it stated that, and I need to quote, in considering the force used by Guinea in the arrest of the Saiga, the tribunal must take into account the circumstances of the arrest in the context of applicable rules of international law. And it continues to say that international law, which is applicable by virtue of Article 293 of the Convention, requires that the use of force must be avoided as far as possible. And when it is unavoidable, it must not go beyond what is reasonably and necessary in these circumstances. Considerations of humanity must apply in the law of the sea as they do in other areas of international law, unquote. Taken together with the tribunal's dictum in the same case to treat the ship and as a unit by stating that the ship and everything on it and every person involved and interested in its operations are treated as an entity linked to the flag state, and that the nationalities of these persons are not relevant, was a clear signal of what something was going on. And this should be seen against the fact that human rights were mentioned in 1995 in the UN Secretary General Annual Oceans and the Law of the Sea report for the very first time. And human rights reference did not appear again until 1998. Today, the human dimension of the Law of the Sea is clearly recognized and visible both in the UN Secretary General reports and in the annual UN's General Assembly resolutions. It is also dealt with in various fora, such as the IMO and the International Labour Organization. Still lacking, however, is the gender dimension in the Law of the Sea context. How many times do you think that gender or women are mentioned in the most recent Secretary General report or in the UN General Assembly resolution from 2021? The answer is 1. in the UN Secretary General report. And then in relation of the need of gender balance in the regulatory process, in the regular process. And it is also mentioned once in the Law of the Sea resolution. And then for the simple reason that women appear in the title of a convention that is referred to. I therefore believe that the prize-winning book, Gender and the Law of the Sea, edited by Irini Papanikopoulou, should be compulsory reading at every course on the law of the sea. There is, however, one institution that should be praised for its work in this area, and it is the World Maritime University and the Sasakawa Global Ocean Institute. The work they do, ranging from empowering women in the maritime community to improving gender equality in ocean research, is of utmost importance. So thank you, Rona Long and Clive Schofield, for the work you do. And a special thanks also goes to the WMU President Cleopatra Dombia Henry for her work. And she has also been elected on the Lloyd's list of the 100 annual ranking of the most influential people in shipping, inter alia, for her work in advancing the role of women in maritime and ocean professions. The rest of the community, the maritime community, I think has a long way to go. The third element is the encouragement in the convention to develop cooperation and separate agreements. Yesterday, Dr. Tara Davenport gave an illustration of the fora that address matters regulated by the convention. The institutions created by the convention remain the same: International Seabed Authority, the International Tribunal of the Law of the Sea, the Commission on the Limits of the Continental Shelf. But as Dr. Davenport showed, Tara has showed by her picture yesterday, the numerous UN bodies and programs, as well as other organizations and entities that address law of the sea matters, whether they do it directly, have addressed law of the sea matters, whether they do it directly or indirectly. Apart from all regional fisheries management organizations, let me just mention the European Union, the African Union, and the Arctic Council. And this is how the unconventional lawmaking in the law of the sea develops. And if you would like to study this further, I would like to join Nilofer in recommending the book Unconventional Lawmaking in the Law of the Sea, edited by Professor Natalie Klein. It has just been published and offers an abundance of examples of international agreements, policies, and understanding that is intertwined with traditional treaties. All this is in fact encouraged by the convention through its provisions of cooperation, which stretches from urging states to cooperate to obliging states to cooperate. We just have to look at Article 311, which presumes that there will be new agreements. My fourth point was the protection of the environment, but due to the lack of time, I will not have the time to address it today. So what are the most important challenges that the convention has faced? Well, I think we all know them. It's been the implementation agreement, the fish stocks agreements, and the forthcoming BBNJ negotiations, so skillfully led by Ambassador Reina Lee. I do think that the convention and the structure of the conventions has managed to meet the human dimension, maritime security, the sustainable development goal, and hopefully also the issues relating to continental shelves. So are there any obsolete provisions in the convention or less relevant provisions? I think there may be one candidate, and what I'm thinking of is Article 109 on unauthorized broadcasting from the high seas, applicable also to the EEZ. Well, the article has its roots in a political situation in 1950 when broadcasting was often a state monopoly, and states and individuals and persons wanted to listen to other types of programs than those that were broadcasted by the state. Today, the internet communication goes through cables, and this leads me to my final remarks. What are the future challenges in the law of the sea context. And I would like to say this relates to the cables, flag state responsibility, autonomous vessel, and sea level rise. And in this context, I just want to mention that although cables are regulated by the convention, the laying of cables and pipelines as well are surrounded by several legal question marks that remains whether the details of the rights and of the responsibilities of the states and owners involved are yet to be identified. And I'm very grateful for the work that Tara and the team at the Center for International Law is doing in this context, in the context of the International Law Association's working group. The flag state regime continues to be addressed by the IMO, so is the issue of autonomous vessel. And the sea level rise, well, we've heard a lot about that, and I don't need to say anything further. So with these words, Lionel and colleagues, I think I'll conclude my presentation. Thank you so much.
Thank you very much, Ambassador Jacobson. Thank you for your deliberations and thoughts about how the UNCLOS regime situates itself in the wider context of the UN structure. Your thoughts about its dispute settlement mechanism, and also your thoughts about the obligation to cooperate found in the convention. And thank you also for sharing with us your sense of the challenges that the convention faces. And I think there are at least two that certainly I think give us much more food for thought. And the first is the article on unauthorized broadcasting, and the second is, I think, the bringing in of the gender dimension into the convention framework. Okay, I turn now to our last panelist, and he's been mentioned many times, so I'm not sure there's much need for introduction. Professor Tommy Koh is Professor of Law, National University of Singapore, Ambassador at Large at the Foreign Ministry of Singapore, Chairman of the Governing Board for the Center of International Law, and among his long list of achievements, the most pertinent, I think, for us is his presidency of the Third UN Conference on the Law of the Sea, which adopted the 1982 Convention. So I think, Professor, we're going to invite you to share some thoughts on how things have developed as the Constitution of the Oceans has taken on a life through implementation and state practice in the past 40 years, and also, I think, some thoughts on some of the personalities that you think have actually made a real difference. The floor is yours.
Thank you, Lionel. I want to begin by sharing some good news with all of you. One of the speakers in panel 6, my good friend Daphne Hong, has just been promoted to being the Solicitor General of Singapore. Let's give her a round of applause. I think we are all very proud of you, Daphne, and wish you success in your important new responsibility. Being the last speaker in the last panel, it's very challenging. So I've been wondering, what can I say that will retain your attention, that is interesting, and yet has some substance. So I've decided to use my 15 minutes to tell you 3 stories. Yeah. Each of the stories will have a moral or lesson. So my first story is about the International Tribunal for the Law of the Sea, UNCLOS. When we were negotiating Part 15, there was some controversy on whether or not we need a second court in addition to the International Court of Justice. Some of my Western colleagues said there was no need to create a second court. But others felt that we need a specialized court to help states parties who disagree about the interpretation and application of the convention to settle their differences. In the end, we arrive at a compromise where we have several modalities of dispute settlement. In July 2003, Singapore neighbor Malaysia initiated arbitral proceedings against Singapore concerning Singapore land reclamation activities in the Strait of Johor and in Tuas. In September the same year, 2003, Malaysia applied to UNCLOS for a provisional measure to stop Singapore's land reclamation activities pending the outcome of the arbitration. My government appointed me as the agent. And my boss at the ministry at the time was Professor Jacobson. I recall that some of Singapore's foreign legal advisors were worried about going to UNCLOS. They thought that UNCLOS was more political than ICJ. They also feared that the judges in UNCLOS were more environmentally minded than judges in ICJ. I didn't share their misgivings. After all, I had a hand in creating this new court, and most of the judges at the time were friends and colleagues from the Law of the Sea Conference. Oral proceedings were held at UNCLOS over 3 days in September 2003. And this is a compliment to UNCLOS. 8 days later, UNCLOS delivered its judgment. The tribunal rejected Malaysia's request for a provisional order. Instead, it did something very unusual. It ordered the governments of Malaysia and Singapore to establish a group of independent experts to verify the facts. Why did they do that? They did that because the dispute between Singapore and Malaysia was fundamentally about facts and not about the law. And so the government of Malaysia and Singapore each appointed 2 experts, and the 4 experts were given a year to undertake the study. A year later, the 4 experts submitted a unanimous report. And I was so pleased that they were inspired by their professional integrity rather than their political loyalties. So the 4 experts worked well together as a team, and they submitted a unanimous report to the 2 governments. Both of us accepted the report. And based upon the findings of fact in the report, the 2 delegations returned to the negotiating table. And after 2 rounds of negotiations, we were able to agree on a settlement agreement. And I will never forget the day, 26 April 2005, when a settlement agreement was signed here in Singapore by the agent for Malaysia and myself, witnessed by our 2 foreign ministers. Based upon that positive experience, I want to say that the negative sentiments about UNCLOS were unfounded. In my view, UNCLOS acted promptly and with wisdom. The tribunal's decision to order the 2 governments to establish a group of independent experts led the way to the successful negotiation of a settlement agreement. So that's my first story. My second story builds upon what Daphne Hong had told you about Straits use for international navigation and Article 43. I just want to tell you my personal story of helping to implement Article 43 in the Straits of Malacca and Singapore. Article 43 enjoins the Strait states and the user state to cooperate for the safety of navigation and the prevention of pollution. In the past, only one user state, Japan, was willing to help the 3 strait states. And I felt that this was not fair, and I took it on as my mission to persuade the other user states to share the burden with Japan. I worked closely with Secretary General William O'Neill and then with Admiral Mitropoulos of IMO, and I had great support of Robert Beckman. So I convened 2 international conferences on the Straits of Malacca and Singapore in 1966 and then in 1999. But Bob and I were not successful because in 1999, Indonesia was not ready and the user states were not ready. The breakthrough occurred in 2007. In September 2007, IMO convened a meeting here in Singapore to adopt a cooperative mechanism for the Straits of Malacca and Singapore. And I want to tell Dorota that I was so pleased when the IMO asked whether I could chair that meeting. Yeah. The Straits of Malacca and Singapore are the first and only straits used for international navigation that has adopted a cooperative mechanism under Article 43. The cooperative mechanism consists of a cooperative forum, a project coordination committee, and an aids to navigation fund. I'm happy to report that China, South Korea, Australia, the United States, India, Greece, Germany, and Norway have joined Japan in the cooperative mechanism. They are assisting the 3 strait states in implementing the projects with financial as well as technical assistance. I conclude the second story by asking, isn't it time for the other straits used for international navigation to emulate our example? My third story is about a man called Satya Nandan from a small country called Fiji. Satya Nandan was the rapporteur of the second committee in the third conference. As you know, the conference began in 1973 with no basic text, and the conference was floundering. So in 1975, at the Geneva session, I proposed to the conference that we request the chairman of the 3 main committees to offer us an informal single negotiating text. I wasn't sure whether the conference would agree because this is giving the 3-person enormous power, you know. But I guess we were pretty desperate and the conference agreed. Now, the chairman of the second committee, which is the most important committee, was an ambassador from El Salvador called Galinda Pol. Yeah, very nice man, but very short-sighted, you know. So when he was walking along the corridor in the UN complex in Geneva, he didn't see that there was a glass door. And he walked straight into the glass door, which shattered, and it injured him, including his eyes. So he was not able to carry out his duty, and he called on the rapporteur, Satya Nandan, to draft the treaty articles on his behalf. Satya Nandan did it alone with one person to help him. And this one person was a young secretariat official from Iceland called Gudmundur Eriksson. And they were working in evening because during the daytime they were attending meetings. So these 2 fellows, working evenings, drafted all these important draft treaty articles on subjects under the second committee. And that's not all. That's not all. At the third conference, Satya Nandan played a very important role. He co-chaired with a British colleague a private negotiating group on straits. And the draft treaty, the treaty articles on straits were drafted by this private negotiating group. He also chaired a negotiation between the group of coastal states and a group of landlocked and disadvantaged states and arrived at an agreement. He was also the person who brokered the compromises on archipelagic states and archipelagic waters and archipelagic sea lanes. So he made an enormous contribution to the success of the third conference. At the end of the conference in 1982, the then UN Secretary General, Javier Perez de Cuellar, offered me a job. He wanted me to join his cabinet and be the special representative of the Secretary General on the law of the sea. I declined his offer and suggested that he offered a job to Satya Nandan, which he did, and Satya accepted the job. Before the convention came into force in 1994, Satya was determined to do something that would bring the United States back to the convention. And with the blessings of Javier Perez de Cuellar, Satya, in his unique style, conducted discreet consultations with all the stakeholders. The objective was to amend Part 11 and Annex 3. Miraculously, he succeeded, and he embodied these in an implementation agreement of 1994. The legal advisor at the UN told him that this is illegal, that you cannot amend the convention in this unconventional way. But Satya was a pragmatist. The implementation agreement was adopted by the UN General Assembly, subsequently signed and ratified, and came into force. There's something else that Satya Nandan did. Some of you may know that in addition to the Law of the Sea Conference, the UN also entrusted to me another major international conference, the UN Conference on Environment and Development, which was held in Rio in 1992. And when I was chairing the negotiations in 92 in Rio, I saw an opportunity for me to give a mandate to the UN to negotiate a new agreement on straddling fish stocks and highly migratory species, which is contained in one of the outcome documents in 92. And the Secretary General appointed Satya Nandan to undertake those negotiations, which led to the 1995 implementation agreement on fish stocks. Satya also chaired the negotiations which resulted in the agreement to establish the Western and Central Pacific Fisheries Commission. Finally, he was the founding Secretary General of the International Seabed Authority, a post he held for 12 years. And the current Secretary General, Michael Lodge, is one of his disciples. So I want to conclude this third story by making 3 points. First, in multilateral diplomacy, a capable diplomat from a small country like Fiji can make an outsized contribution, much more than diplomats from much bigger countries. My second point is that diplomacy is often thought to be an amoral, cutthroat exercise. the leader of the US delegation to the third conference, Elliot Richardson, made a very interesting remark. He said, you know, the most influential delegates at the third conference were the brightest and the straightest. Yeah, the straightest. Those who were cunning and duplicitous were not given responsibility. Satya Nandan was both bright and very straight, honest, transparent. And because he was capable and reliable and honest, people gave him responsibility. Yeah, so that's my second point. My third point is that the third conference was unique in that several individuals made important contributions to the success of the conference. And apart from Satya Nandan, I would identify Jens Evensen of Norway, who chaired a private group of juridical experts and basically helped us to draft the provisions on the exclusive economic zone. I would also point to the leader of the Mexican delegation, Jorge Castaneda, who subsequently became foreign minister. Jorge convened a dinner meeting of a few of us. And after we had a wonderful meal, said, sorry, you cannot leave. I invited you here to work. And we are here to try to resolve one of the most difficult issues at the conference, which was the status of the exclusive economic zone. And finally, you know, we are so proud of the system of compulsory dispute settlement. But that came out of a private negotiating group too, you know. And the people who led this exercise and gave us Part 15 were Professor Louis Cern from the United States, Galindo Poe from El Salvador, Ralph Harry from Australia, and Andy Adedi from Kenya. So these are the three things I wanted to share with you about individuals, about diplomacy, and especially about my dear friend Satya Nandan. Thank you.
Well, thank you very much, Prof. Koh, for, I think, sharing some very, very personal, I think, insights into how the convention has come to life from your experience via its institutions, via regional cooperation, and I think also via personalities who are involved. Before I open up the floor for questions, I wanted to ask if any of our panelists had any sort of reactions to the other presentations that they have heard in the course of this panel session.
Let's go straight to
If
Q&A.
there are none, then let's invite questions from the participants. I'm going to start by inviting questions from those who are in person here in the conference hall itself. Should you ask for the floor, please wait for the microphone so that those who are attending online can hear your question. Then I'm going to go to the online participants, and I think to encourage a more interactive session, when we come to that segment, I will give priority first to those who indicate using the raise hand function on Zoom, before those who pose the questions through the chat function. So I'm sort of giving you that heads up. So let me start with the in-person attendees. Does anyone wish to pose any questions to the panel? Well, I'll start, let me see, with Dorothy first, and then Natalie. Or Natalie first and Dorothy.
Thank you very much, and thank you to all the presenters for fabulous presentations, and especially Professor Koh really giving us those personal reflections on what it was like and who was involved. It was really great to hear. I wanted to go back to Marie's presentation. I was very glad to hear you talk about the issue of human rights at sea, which we hadn't otherwise discussed during the conference, and I think really is one of a key challenge for states and for civil society and all industry stakeholders going forward. So I wondered if you or any other members of the panel would want to reflect on how we could better use UNCLOS to really support both the application and the enforcement of human rights at sea. Thanks very much.
Thank you. Marie, would you like to respond first, and then I'll see if the other panelists would like to jump in.
Thank you. Thank you, Natalie. I hear this echo again. That's why I'm a little bit. See if I can. I think that we have to remind ourselves that the references in UNCLOS is that everything we do should be undertaken in the context of the wider group of the wider international law regulations, and that also includes human rights. So we have to look at when we take decisions, and when we decide what way to go, what measures we're going to take in a specific context, we will always also have to look at this from the perspective of human rights and also from a gender perspective. When I started to work on the human dimension on the law of the sea many years ago, decades ago, as I mentioned, there were no references whatsoever. Now, the fact that no one can use the sea if it is not a human being. If there is a human being, that person is a carrier of human rights. So we simply cannot avoid it. But by also showing on the structural problems of abuses of human rights, such as trafficking, poor labor conditions, issues that I know that the IMO are discussing now in the context of autonomous vessels, we will have to stand up and say that these issues under the Law of the Sea Convention they are not only issues of a technical character. These are issues that we have to resolve so that the individual, the international community, and the individual person in the community can enjoy his or her legitimate rights. And I think that's also the only way for us to promote the sustainable development goals. If we look at the goals and apply them in the Law of the Sea context, we will see how the references and the issue of human rights can simply not be avoided. So we just have to look at the solutions with new lenses.
Yes, thank you.
I'd like to make 2 points. COVID-19 had a devastating impact on seafarers. Many seafarers were stuck on board their ships. The ports would not allow them to land. They couldn't go home. They couldn't fly to join the next vessel. So I'm very proud of the fact that the Maritime and Port Authority of Singapore was a thought leader in this respect. Bob and I put a lot of pressure on our friends at MPA, but they came through, So they allowed seafarers to come ashore. They created a bubble whereby they could go from Singapore to a connecting flight to take them home or to take them to wherever they wanted to go. So this is clearly a case of human rights. Right? The other thing I'm interested in is that some investigative journalists and NGOs have reviewed horror stories about the exploitation of workers on board fishing vessels in this region. And I think we should do something about this, I mean, workers on board fishing vessels are not slaves, And it's totally unacceptable that in 2022, we have workers who are treated as slaves or prisoners on board some fishing vessel in this part of the world.
Yes, Nilüfer.
Yes, thank you so much, Natalie, for that very pertinent question. And we didn't really address that in this day and a half, but perhaps we should do something separate on that. That is an area that has been developing very much so. And you know, of course, that there was the recent Geneva Declaration on human rights at sea that I understand that was open for public comment, and that's something that we should really focus on. But it has become a very critical issue, starting from the migration issues, the lives lost at sea, not saved, horrible stories. And I think what Tommy Ko just mentioned, it's horrific. The slavery at sea, actually. And so when we look at the Law of the Sea Convention, particularly when we're looking at the high seas are being abused for that, even when you look at the slavery provisions under Article 101, I think maybe we need to focus a little bit more on that, because those are all based on old conventions as well. So I think this is something that needs much more attention, but I think the Law of the Sea Convention is certainly open for addressing that. Thank you.
Right, thank you. Dorothy, would you like to ask your question? Dorothy's from the International Maritime Organization.
And Clive.
And then Clive after that.
Thank you very much, and thank you to all panelists, and especially to Professor Koch. Of course, those remarks about how delegates work and how diplomacy works are very, very valuable, and we realize how much we are deprived right now during the pandemic of those opportunities of informal negotiations and dinners and doing things, behind the scene, and then coming back to the plenary with a solution. So this is something that unfortunately we don't have right now. But I also would like to refer to 2 points. One is the human rights at sea, and of course IMO is working on it from the perspective of seafarers, the fair treatment of seafarers, abandonment of seafarers, and various subjects that are on the agenda of the legal committee. So I encourage all those who are interested in this particular subject to refer to the documents of the legal committee that met just last month. And I thank very much Ambassador Jacobson for pointing out at the women in maritime issue. And of course, WMU is carrying out the very, very important work, which is a follow-up of the World Maritime Day theme of 2019, empowering women in the maritime community. And I'm very pleased also to inform everyone that in December 2021, the IMO Assembly adopted a resolution and established 18th of May as International Women's Day in Maritime. So we will be celebrating this day every year from now on. And further information about all the programs of IMO, WMU, and also IMLI are available on the IMO website. Thank you very much.
Thank you. Judge Pick, did you want to respond to the question?
Just quickly, as has been mentioned, I also hear echo. But anyway, human rights issues have been raised before the tribunal, sometimes successfully, sometimes without success. So it really depends on the context in which human rights issues are raised. In this regard, of course, there is a clear distinction between question of jurisdiction on the one hand and that of applicable law on the other hand. But anyway, there are many legal instruments which directly address human rights conditions or labor conditions, has talked about this terrible labor condition on fishing vessels, whether any dispute related to such condition can be dispute concerning interpretation or application of the convention. It's difficult to say in general. It really depends on how issues are raised and before vote before the tribunal. But anyway, as has been mentioned, the tribunal expressed its view on human rights condition in certain contexts. Thank you.
Thank you, Judge. Professor Schofield from the World Maritime.
Very much indeed, Mr. Chairman, Lionel. The theme of this conference is, of course, the Law of the Sea Convention at 40, an assessment. And many of the audience, many of the participants are academics, and we tend to be built to criticize and find gaps and find issues that have not been resolved. But at the same time, what has been clear over the last day and a half is there's so much to celebrate about the United Nations Convention on the Law of the Sea. And even Judge Pike was generous enough to say he was fairly pleased with how the convention has stood the test of time. I really enjoyed the chance to hear your own reflections, Ambassador Ko, on some of the issues that came up in the drafting of the convention. I wondered whether you might grace us with some thoughts about what was the one thing, or perhaps if you prefer the three things, that kept you up at night, that might have been the key things that would have prevented this amazing convention that has such breadth and depth and such an amazing degree of number of parties who are now party to the convention, where we only have 152 United Nations member states who are coastal, and yet we have 167 states parties plus the European Union. But your reflections, your thoughts of what do you think were the key roadblocks that you saw preventing?
No, there were so many issues, right? So let me share with you the three things that preoccupied me towards the end of the conference. I think we really struggled to try to accommodate the Reagan administration's demands. As you know, President Reagan did not follow the bipartisan US oceans policy. I mean, in that respect, he was a disruptor, a revolutionary, you know. He was more nationalistic than Nixon and others. And when the US delegation returned to the conference, it tabled a book of amendments, which we call the Green Book. The amendments are so extensive that many friends in a developing country wondered whether the United States was serious and sincere or not, or they were trying to wreck the conference, you know. But people like Satya, myself, had good links with the US delegation, and we really struggled to try to understand what were their most important demands and to see whether it was possible for the developing country to accommodate them. So I was very disappointed that in spite of our best efforts, we couldn't satisfy them. And towards the end, friends and allies of the United States actually came to me in private and said, don't delay anymore, because if you do, you may lose what we've already achieved after 9 years of hard work. And these are friends of the United States, you know, said, put it to the vote. That it's impossible to satisfy the Reagan administration. So that was, for me, a very agonizing moment, you know. I knew that the conference would fail if we didn't do something, which is that we agreed to extend the breadth of territorial sea from 3 to 12 miles, but by this extension, there are 116 straits in the world whose breadth is less than 24 miles. So as a result of this extension, the high sea corridors in these important sea lanes would have disappeared, you know. And the two superpowers at the time, the Soviet Union and the United States, made it clear to me that if I'm unable to deliver to them a special regime of passage for ships, aircraft, and submarines through, over, and under these straits, there will be no convention. So this was really a critical issue, you know. It's sometimes very difficult to negotiate in a conference of 150 plus countries, you know, because many countries had dug in their position. So my two dear friends and neighbors, Indonesia and Malaysia, for example, said, no, innocent passage, nothing more. But I pleaded with them and said, if that's all you can give, there will be no convention, you know. But they refused to budge, you know. So Fiji and the United Kingdom took a decisive initiative. They decided to convene a private negotiating group on straits. And what they did was they handpicked 13 delegations and excluded the two superpowers. The US and USSR were not included. They excluded the countries which they regarded as extremist strait states. So Indonesia, Malaysia, and Spain were not invited. So those of us who were invited were either moderate strait state or moderate maritime states. And it was this group of 13 countries that give you the chapter on straits, you know. That's the second critical issue. The third issue, which was so difficult to resolve, was maritime delimitation. In fact, you may recall that it was the last issue to be resolved, you know. And many of my friends are still angry with me that I didn't really solve the problem. And I gave them a formula which was so general and ambiguous, it could mean anything, but it's not true, you know. I mean, we had two opposing groups of delegations, and I asked Satya to help me. We commuted to one group, to the other. We tried various formula with them, and nothing was acceptable except what you find in a convention. You know, it's not very good, it's not ideal, but you know, in a negotiation, you sometimes have to settle for the lowest common denominator. So I think those were the three of the many issues that preoccupied us. Thank you, Clive.
Thank you. I'm going to turn to Tara on my right just to see if anyone has raised their virtual hand on Zoom.
No one has raised a virtual hand, but we have a question from one of our former colleagues.
Why don't I take one more question from the floor and then we'll take that question. Judge Karoma, you raised your hand.
Thank you, Mr. Chairman, and I would like to congratulate the distinguished panel for taking us through a memory lane, as it were, through the story, giving us the historical background to UNCLOS. I decided I must apologize for taking the floor at this stage, and I want to say you have been an excellent chairman. I don't mean to embarrass you, but you have been. I wanted to comment on the important issue raised about human rights at sea, and I'm sure it would not, members are very much aware. I think Dr. Locke from the IMO, the International Labour Organization has done tremendous work on that. So Ambassador Jacobson early on referred to Dr. Dubuya Henry. She has a background in the law of the sea and was the director of the International Labour Organization. And the ILO has a maritime labor organization on law of the sea matters. with respect to seafarers and so on and so forth. So I've been associated with the ILO for many years. I chaired the committee of experts. I thought I would have been derelict in my duty, not bringing that to the attention of conference. So the matter has been very much addressed, even the accommodation of seafarers and other measures. There is a major treaty widely ratified, the Maritime Labour Organization Treaty. Thank you very much.
Thank you, Judge, for your observations. Tamara, do
It's 4:29. Would you, we're supposed to have the closing session at 4:30. Should we?
Take one question.
maybe we just take the question from the chat group.
Sorry, I have to go to the. Okay, the question from one of our who's currently at WMU. Actually, Chen, would you like to ask it live? Okay, never mind. I'll just read it to save time. Sorry, I shouldn't have offered that. Thanks, Prof. Ko, for sharing your stories and insights. It is exciting that Ambassador Lee is carrying the tradition on at the UN. Given the current concerns and perhaps more complicated international situations, what advice would you give to delegates at the ongoing BBNJ negotiations to find compromise and reach consensus? And I think that's actually a very fitting question.
I think we should repeat what Rina Lee said yesterday. Support the president of the conference, Rina Lee.
Do any of the other panelists have a response to the question?
I dare not.
All right, well, this, I think, brings us to the end of our panel session, so please join me in thanking our panelists.
We remain here or we go down?
I think they wanted to.